everybody, it's Cole Boling with the Boling Group at Keller Williams Realty, One Legacy Partners in Topeka. And in conjunction with my wife, we are going through all of the pages of the real estate contract. Today, we are on page 7. Page 7 is pretty much the last main section of our contract. So what this says is, what this is about the mediation section and the additional provisions, signatures, and the receiving escrow type stuff. So we'll get started, right? Straight into mediation. So mediation, unfortunately, we have to have things like this in our contracts because people like to sue people. It's just one of the parts of our world that we live in. However, the way that our contract's written is we do have a mediation clause. Any dispute or claim arising out of or relating to this contract, the breach of this contract, or the services provided in relation to this contract shall be submitted to mediation in accordance with the rules and procedures of a home seller's, home buyer's dispute resolution system. You can see more about this in detail if you go to the sunflowerrealtors.com website. So you have to do that prior to filing any lawsuit. Disputes shall include representations made by the buyer, seller, or any listing or seller brokerage or their agents, employees, and associate brokers in connection to the sale, purchase, financing, condition, and other aspects of the property, including, without limitations, allegations of concealment, misrepresentation, negligence, and or fraud. Seller and buyer shall pay an equal portion of the mediation fees and the cost, and any party to this mediation will pay their own cost of counsel, if any. So any agreement signed by the parties pursuant to the mediation conference shall be binding. The following matters are excluded from mediation hereunder, which is any earnest money disputes, judicial or non-judicial foreclosure, or other actions or proceedings to enforce a mortgage or escrow contract, and unlawful detainer action, the filing or enforcement of a mechanics lien, any matter in which the jurisdiction of jurisdiction of a probate court, disputes during time before closing occurs, or in scheduling that has occurred. Any matter that would involve a claim less than the maximum from a small claims jurisdiction under the state of Kansas law, or a violation of the Kansas real estate licensing law. Mediation fees will be prepared before the mediation begins, and a failure to pay the prorated share will constitute a default in the obligation to mediate. Now, with all that technical stuff being said, basically, if it's an issue in the general sense of the contract, if there's things on behalf of the seller they don't disclose, or buyers or agents don't disclose, we have to mediate. If we get into a lot more legal type stuff or criminal acts, vandalism and damage and anything like that, we do have to go a different route, which would be a full-blown lawsuit. However, mediation has to come first. Okay, now we got that out of the way. So now let's get to the additional provisions. Typically, this is the spot where we, as real estate agents, can write in extra pieces of a contract. This is anything tangible that is real estate, not personal property, right? So we won't put any like refrigerators or couches or anything in this section. We'll be doing a video on that later. But this is where we were going to ask the seller if anything to do with cost of the transaction, if they're going to pay for closing costs, they're going to pay for the prepaids, if we want them to pay for inspections, if we want something very specific to happen, because typically the buyer does pay for their own inspections, this is where we would write it. Like I said, we don't put any personal property on this portion of the contract. This is purely for the details that we're going to be adding in conjunction with the real estate transaction. We can make other offers here. We can put in details of escalation clauses, which is where we have an offer that goes against another offer over another offer. It's a very interesting process. We could put those details here. We can basically add anything in here that we want to make sure is taken care of prior to closing. So if we have a something that we know is wrong with the property, we would say seller to fix broken rafter and ceiling above garage. We'd put that, something like that right here. So this section really is open to us putting together how much information we want inside of the contract to make sure that everybody is protected. This contract constitutes the entire contract between the parties, and there is no representations, warranties, conditions, contracts, or agreements other than those expressly set forth herein. No other agreement, statement, promise, warranty, or representation may be made by any party to this contract or by any employee, officer, or agent of any party that is not in writing and signed by all the parties of this contract. It shall be binding. This contract shall extend to and become binding upon the heirs, the executors, the administrators, the successors, and assigns of the representative parties. It's very tongue-twisty lawyer lingo. Prior to the closing of this contract, buyers shall not sell, assign, transfer this contract or any interest of the property without first obtaining the written consent of the seller. We do see sometimes people wholesaling properties with that. What they're saying there is that the person saying, oh, I'm going to buy it, but I'm going to sell it over here before we actually close. So seller gets the table and the buyer they thought they had to deal with is not the buyer they end up having to deal with. We have to make sure that the seller is aware of that and has to be in writing. Then this is a legally binding contract. If not understood, seek the advice of attorney. In witness whereof the parties have executed this contract as the date last signed or initialed. This is where the sellers will all sign, the buyers will all sign. We're going to jump a section here and just down to the bottom, and we will have to initial the bottom of each page. Then the very, very last section on here is just the receipt of the escrow money. So the earnest money you put down on the property, an escrow agent will have to receipt that. They'll put the amount there, when it was executed, who's holding the money, and they have to sign it. So thank you again for tuning into page 7, and we will see you on the next video. Bye. All right, now stay tuned for our next video, as we're going to go over exactly what we do when we have a fully executed contract. This is Cole Boling with the Boling Group at Keller Williams One Legacy Partners in Topeka, and we are here for all of your real estate needs.